164 of 2025, Hamasi Singh and others versus National University of Lesotho Student Representative Council and others.
Once again, my lord,
Yes.
I am advocate and PR on behalf of the applicant.
Yes,
If it pleases the court, once again, my lord, I am advocate Hoboko, initials KS, appearing on behalf of the respondents. My lord, may I put on record advocate to KLA, who will also be assisting me in this representation on behalf of the respondents, my lord.
You are still appearing for 1, 2, 3, and 6.
That is so, my lord.
Okay. With who?
Advocate to KLA, who unfortunately, my lord, was unable to secure his attendance before this court today.
L-E, is it L-E?
LA.
L-A.
To get initials LA.
L-A. Yes, counsel.
Yes, my lord.
You have to explain.
Yes, my lord.
I thought that the applicant will start. No, you want to start?
May I beg the indulgence of the court to start, my lord, for this reason. That, my lord, as can be discernible from the papers before you, the respondents in this matter have raised several issues with the applicant's application, and at this particular juncture, my lord.
No. What issues now are looking forward? You haven't filed anything.
We filed our answering affidavit, my lord, and in that answering affidavit, at paragraph.
Invitation to oppose or otherwise.
Yes,
I
ma'am.
haven't had an opportunity to have a look at it. Okay.
Okay, my lord.
Okay, yes. That will be cool.
Yes, my lord. And in the answering affidavit, at paragraph F, rather part F, paragraph 20 of the answering affidavit, the respondents, my lord, have raised a preliminary point of law, which is that of the court's lack of jurisdiction to hear this matter, because the applicants have approached this court prematurely and competently. Why is that so, my lord?
May I ask you, just before, just to interrupt you, do we have evidence of service here?
Yes, my lord, that is page 65 of the record.
Page 65. So they have all been served.
They have all been sent.
The respondent.
That's a copy. Thank you.
Okay, that's it called.
My lord, now that issue is out of the way, I was addressing the court on a preliminary point of law that has been raised by the represented respondents, which is that of the lack of jurisdiction of this honorable court to hear this matter. The basis or the leg upon the foundation of the lack of jurisdiction is the respondent's failure in this particular instance to exhaust the internal or domestic remedies provided for by the enabling statute of the National University of Lesotho, which is the SU Constitution. At paragraph 42 of the same SU Constitution, my lord, if I could quote verbatim, it reads, paragraph 42 lists. It reads as follows. That is paragraph 82, sub 8, SU Constitution.
Is that covered in your in
Yes, my lord. That is paragraph 20 still.
okay.
Yes, and that paragraph, I just wanted to quote this particular part verbatim for the benefit of the court. May I start at paragraph 42, sub 6? If any candidate or his representative objects to the results of the ballot votes of that particular day, such candidate shall be entitled to a recount. And at 8, it reads, any objection by any member of the SU concerning elections shall be lodged with SJC within 24 hours after announcement of the election results. Now at paragraph 20, my lord, the intention of the legislature in regards to the SU Constitution is very clear in its explicit terms. It provides that if any member of the SU has an issue with the outcome of the elections, that member has to exhaust local remedies by 1, lodging the complaint with the Chief Electoral Officer and also with the SJC within 24 hours. That is per the provisions of this Constitution. Now the question that should be asked by us before this court is, have the applicants in this particular case exhausted the available constitutional internal remedies provided by the Constitution? And my lord, without any fear of contradiction, the answer is in the negative. That is to say, the applicants have jumped the ship to come to the High Court in the face of the domestic and internal remedies that exist, that they should have explored but have failed to do so. My lord, at paragraph 21, we refer this court for purposes of its comfort.
You are referring to paragraph
21. We have just moved from paragraph 20. We are now transitioning to paragraph 21.
Yes, sir. While we are still on paragraph 20, the issue raised there relates to what paragraph of the Constitution?
That is paragraph 42, sub 6, read together with 8. The totality of those two paragraphs is on exhaustion of local remedies.
42.
Paragraph 6, read together with 8.
42, 6.
And 8.
And 8. Of the SU Constitution.
Yes, my lord.
Do I have an opportunity of seeing that? Do you have copies there?
My lord, unfortunately the application is devoid of the Constitution. However, I have an electronic copy, my lord. If I may I approach the bench to...
No, I want to... what's going to happen? You are addressing the court on the basis of your laptop, isn't it? Okay, you are saying you are relying on paragraph 42, 6, and 8 of the SU Constitution.
Yes, my lord.
They deal with exhaustion or remedies.
Thank you. Yes, my lord. In an event where any member has issues with the outcome of the elections of the SRC,
if a party has issues with outcome of elections.
With the outcome of the elections could be irregularities, unlawfulness, or any kind of discomfort.
That he or she has to do what?
to exhaust the local remedies. How? By approaching or by lodging such a complaint with the Chief Electoral Officer within 24 hours, and also the SJC is another avenue within 24 hours.
Chief Electoral Officer and who?
And the SJC, or the Students' Union High Court, within the time frame of 24 hours after the publication of the results by the Chief Electoral Officer.
Yes, ma'am.
And it is imperative to mention at that point, my lord, that the applicants in this case have failed to exhaust the local remedies and have only come to this court prematurely to cry irregularities and the unlawfulness of the election results without exhausting the local remedies.
Yes, Advocate.
Yes, my lord. And in the face of that failure on the applicants, then we submit that to have jumped the ship to come to the High Court of Lesotho in Maseru as an application that is founded on prematurity and incompetence. With the indulgence of His Lordship, I wish to refer you, or this court, to the Court of Appeal decision in Monarchic Catering and 5 others. Court of Appeal decision in Monarchic Catering and 5 others versus Ministry of Health Tender Panel and 11 others. It is the Court of Appeal case number 84 of 2023.
Case number 84.
Number 84 of 2023. Now, at paragraph 86 of that decision, my lord, the Court of Appeal in that particular decision provides the position of the law that where the intention of the legislature is clear that certain domestic remedies or internal remedies be exhausted before going to the courts of law, now the courts of law will delay their jurisdiction to enable the local remedies to be exhausted. That is that Court of Appeal decision, paragraph 86, my lord. And we also have the decision of this honorable court in Mutibedi Khojan versus the school secretary, ACL schools, and 5 others. Mutibedi Khojane versus the school secretary, ACL schools, and 5 others. ACL schools and 5 others.
Yes.
It is civil application 245, civil application 245 of the year 2020 at paragraphs 3 to 5. Now, the totality of these paragraphs, my lord, they also deal with the importance of exhausting the local remedies where the enabling statute, which in this case is the SU Constitution, for them to be exhausted before approaching the courts of law. My lord, also at paragraph 43 of the Director of Public Prosecutions versus Nyeoe, it's another Court of Appeal decision. If I should quote verbatim paragraph 43, what it says or it reads.
Of which case?
Director of Public Prosecutions versus Nyeoe. It is also on the issue of jurisdiction.
DPP versus Nyeoe.
Yes, my lord. Case number 49 of 2020.
Is it civil or criminal case?
It's the civil.
Civil.
It's a civil aid case, my lord.
Civil what?
Civil case number 49.
Civil application? Civil
Yes, civil application, my lord. Actually, no, it's a criminal case.
So it's criminal.
Yes, my lord. Number
Criminal
49.
Application. Or
Yes, application, my lord.
criminal application number.
49 of 2020.
Okay.
Paragraph 43.
43.
My lord, permission.
The High Court decision.
Court of Appeal, my lord.
Court of Appeal.
Yes, my lord.
I thought you were saying criminal application 493. Is it a C of A criminal?
May I just confirm the citation, my lord?
Yes, please.
May I correctly confirm the citation of this case? My apologies, it's actually civil application. Civil application, number 49.
Civil application.
Number 49 of 2020. Court of Appeal decision.
What's the Court of Appeal number? Was a civil application 49 of 20 says it's a High Court decision. The Court of Appeal one will be C of A civil number.
That is the citation as it appears from the case.
Is it?
It's C of A in brackets CIV 49 of 2020.
Okay.
Yes, ma'am.
Yeah.
Permission, my lord, to quote verbatim paragraph 43 of the same judgment.
Okay.
I'll just read from line 1, 2, 3, 4, 5.
Any idea when it was decided?
It was decided on the 14th of May 2021.
2021.
14th of May 2021.
Yes. Okay.
Paragraph 43.
Mm-hmm.
It is tried that the power and competence of any court is not unlimited. There will always be some limitation on the jurisdiction of every court imposed either by statute or by the common law. In every case, therefore, the court before which an objection to jurisdiction has been raised has an unshakable duty to determine the objection first and pronounce itself on the limitations to jurisdiction upon which the objection is based. That is paragraph 43 of the Nyeoe decision. With due respect, my lord, your court this afternoon is sitting on an urgent wall. And the respondents having raised the jurisdictional issue on the failure of the applicants to exhaust clear constitutional and internal remedies in the enabling statute of the SU Constitution, we submit respectfully and for the comfort of this court that this court declines to hear this case on any interim orders sought by the applicants to enable the jurisdictional issue to be fully canvassed, my lord. And even the Nyeoe decision, my lord, it is clear that once the jurisdictional issue is raised, not even the interim reliefs or the interlocutory reliefs can be entertained by the court in which such a jurisdictional issue is raised, my lord.
Yes.
Now, my lord, just for purposes of summation,
Yes.
the applicants in this case, my lord, participated in the elections. They were candidates in the elections. They campaigned. They did manifestos. They are aware of the SU constitution. They sent agents in the polling room, and elections proceeded for 2 days. Only when they realized, oh my God, we have lost the elections, they ran to court in Maseru.
Are you now aware that you are getting into your submissions on agency?
Not necessarily. I was just going to say, at that point where they had problems with the outcome of the elections, then they are aware of the constitution and the internal remedies that exist under that particular constitution. They should or ought to have, as a matter of law and as a matter of statute, to have proceeded to lodge their complaints within 24 hours under the SU constitution with the Chief Electoral Officer and the SGC. But in this case, in the face of this awareness, in the face of the SU constitution, they failed to do that, my lord. And this case, my lord, has come before this court prematurely and incompetently, and on the basis of the Ramepana decision and on the basis of authorities that have provided before this court on this particular issue, we respectfully and humbly pray this honorable court that by virtue of this court sitting as an agent court, that it assumes that it has no jurisdiction to hear interim reliefs in this particular case. That will be our submissions on behalf of the respondents on this jurisdictional issue. Yes, my lord. And in the absence of any questions from his lordship, may I kindly, my lord, sit down, my lord.
You think you have dealt with your issue properly?
On jurisdiction, my lord. On jurisdiction, my lord.
I'm sorry, my lord. That's
And when am I going to get the SU constitution, at least the relevant parts?
My lord, may we facilitate that after this hearing, that we work towards the court having the relevant parts of the constitution. My lord. Yes,
Okay, that's only your reaction to the jurisdictional issue.
thank you, my lord. My lord, I'm going to be very, very short because this is a very straightforward issue. My lord, I should first, without wasting the court's time, indicate that I fully agree with my learned friend in as far as he has made the legal frame, the legal submissions on the issue of Ramepana case and other cases that he has cited. The position that he has stated, my lord, is correct, and I applaud him for that. However, my lord, there are only two issues that I want to invite the court to look into. My lord, the applicants in this matter are not before this honorable court in any way, my lord. They are not here in any way whatsoever challenging the outcome of the elections. I also, my lord, would want to concede that in as far as the second to the last applicants, which is the 10th applicant, yes, indeed, they participated in those elections. But that was not the case with the first applicant. And that being the case, my lord, the respondents cannot come here and said all the applicants had a hand in these elections, cannot come here to say they are only now complaining because they have not been voted by the majority.
Let me just get your submission properly. You are saying applicants are not before this court challenging what?
They are not challenging the outcome of the elections. Yeah, and my lord, the provisions that my learned friend has referred the court to, they are to the view that once one has an objection underlying word there will be objection and ballots. And now what we are submitting before this honorable court is that the applicants are rather not here to challenge the ballots. They are not here concerned about the outcome of the elections. That, my lord, is very clear. It can be seen from our prayers. There is no prayer in our founding affidavit that talks towards the results of those elections.
So you are saying the provisions related to the respondents relate to the outcome of the elections?
They relate to the outcome of the elections. And that is what we submit, what we are here for. So in that respect, my lord, we submit that we cannot be taken now to be said to go and follow the provisions that do not fall within the category of what we are complaining on. We submit, my lord, that the first applicant, I'll be very particular with the first applicant, my lord. The first applicant never took part in those elections. Maybe, my lord, for the court to appreciate what really happened here, if we could give a brief factual background, the court permit, my lord, it will be very clear as to why we are here. Not that the court be told otherwise.
These other applicants, if I may just ask.
Yes, ma'am.
The other applicants who have been there, I don't see anything where they support the first applicant or that they have seen the first applicant is should be this affidavit covers even the other applicants. Why are they silent?
Yes, my lord. That is another thing that we
because they have not authorized the first applicant to file the affidavit on their behalf.
That is true, my lord. We are aware of that. But that is one other issue that we are going to deal with, my lord. When now we are dealing with agency, we are going to deal with that when that aspect comes. My lord, it was only due to the fact that now these applicants are students at the National University of Lesotho, and they are very far from here. It is not very easy for them to come. So when we consulted on the same day that we drafted this application, and my lord, they were not around. So we took notice of the fact that if we are to wait for them to come and depose to affidavits, then we will run out of time that we are already mindful that now there's
then they are not properly before court. If you had not yet been consulted with them, they are not properly before court. Why not then they would join later after they have consulted?
Yes, my lord.
Why not they have not properly before court?
We have consulted, it's just that they have not deposed to affidavit. But my lord, we do not have any problem with any decision that the court might take with respect to those other applicants. And then we are only such that we are only left with the first applicant.
With one applicant.
That's the court places. Then we will not have a problem because my lord, I don't want to waste the court's time. Even the allegations that my young friend are saying that they want to have objected to the SJC blah 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 such things, my lord. I want to admit at this juncture, my lord, that yes, they did not do that. So maybe in any event he might be correct in as far as they are concerned.
Yes, that was just raised that issue, but we are still dealing with the submissions raised by the applicants, the respondents, relate to the outcome of the elections, and applicants are not challenging the outcome of the elections.
Yes, my lord.
Yes,
The applicant, my lord, are not challenging the outcome of the election, but rather, my lord, they are challenging the decision, my lord, to have disqualified the first applicant herein from contesting in those elections, not the results of the elections. And my lord, as far as that part of Article 42.6 is concerned, we submit that the course of action in this particular case does not fall within the ambit of the provisions of that section. And as a result, that the respondent's case on that leg should not stand. We would also, my lord, go to Article 42.8, which now says, it now paves the way that if there is that objection, then a member of the SU concerning elections shall be lodged with the SJC within 24 hours.
Mm-hmm.
Yes, my lord. My lord, on that one, we still maintain the argument that the main reason we are here does not concern the elections, does not concern the outcome of the elections, my lord. But to take the argument further, my lord, we have indicated in our founding affidavit that even this matter that we are here before this honorable court with, it started at SJC. It started before the SJC, my lord. We have indicated that on the 8th, or rather, because the court adjourned on the 9th in the morning around 12:30, the applicant, the first applicant herein, had lodged an application there wherein he was challenging his disqualification from taking part in the said elections. And my lord, we have indicated in our founding affidavit that we are today before this honorable court because that the SJC, my lord, had issued an order that the elections should not proceed. That the elections should not proceed. And while my lord, the applicants were still on that, with the hope that they would come back to now deal with the other applications that the applicants then, that the respondents said were going to lodge. Now they introduced another court, which now came in and then dealt away with that decision, and then now we're having another order, and now consequently the elections. So my lord, we submit that, as we have even indicated in our founding affidavit, that the actions of the respondents, my lord, from the first, second, third, and the sixth have made it very difficult, my lord, to even for even the SJC to sit as a court in that institution. We have stated that in our affidavit. So now, my lord, they cannot do acts which makes it impossible for the court to sit. And then now, thereafter, when the person goes further to look for a remedy, and then they go there to say, no, we want to have started elsewhere. While in actual fact, they know that, as a matter of fact now, my lord, we don't have an active SJC at the National Registry Office. So it cannot hold for them to say, these people ought to have started there. Because there's nothing of that kind there, as They are also talking about the other tribunals. These other tribunals, my lord, are not established as of now within the National University of Law. So we cannot be said that one should go and complain before something that does not exist.
No, just to understand what you are saying.
Yes,
you are saying what is not exist. SJ what?
SJC. That is the court.
Student Judicial Commission.
Yes, the Student Judicial Committee, something of that. SJC, but it's the court there, my lord. It's the student court. So this is the court that we are saying.
It's not in existence.
No, my lord. That the court was constituted, but the actions of the first respondent, the sixth respondent, and others have frustrated that court that so much that even the judges that have been appointed to sit in that court, it's very difficult. It's impossible for them to do anything now. My lord, we can show that after this order that led to the elections was given by the Supreme Appeal of the Appeal Court, the applicant lodged a contempt application before that court, and that application was never entertained, because now those gentlemen say no, we don't feel like now we are still in the position to be handling matters. That is the position. That is the position now, my lord. And we have said those things in our appeal, that it's impractical to go before that court. And for the other tribunals, they are not there. So the only thing, my lord, we submit that was left for this applicant to get justice was to come before this court. We so submit now. And my lord, we are here. We are not even here. The applicant could not come here the first applicant could not come here and complain about the outcome of the election that he was not even party to. Hence, we are saying 42(6) is not applicable in these circumstances, my lord, and it should be ruled out. That will be our submission, my lord, on that issue. That's the court principle.
Yes, by way of a reply, my lord. My lord, the submissions by counsel for applicants are misleading, and they are submissions where he cherry picks which prayers works in his favor. I wish to refer his lordship to page 12 of the report. And with particular attention, prayers 6 and 7.
Is that a notice of motion?
Yes, my lord, notice of motion.
Page what?
Page 12 of the report. Yeah.
Notice of motion starts at 25. Page 12 is the practice.
My lord, under the notice of motion B26. That's what happened.
Thank you so much. Yes, my apologies for that, my lord. At page 26, paragraph 6 of prayer 6 and 7.
Of the final read.
Yes, my lord. Prayer 6 reads that the elections that took place on the 9th and 10th October 2025 be declared null and void as they were unlawfully held. And prayer 7 is that the second and third respondents be directed to arrange for fresh elections within 2 weeks of the order. May I humbly endure, my lord. Now, at a point where I was saying, counsel is misleading the court and is also cherry picking which prayers to take and make reference to. Now, the fact that applicants approach the court to say, we demand fresh elections, that the elections be declared null and void. What you are saying is just an issue of semantics. Why am I saying this? at a point where you say the elections must be annulled, and at a point where you say certain people must be ordered to arrange for fair elections, the ultimate goal is you are disputing the outcome of those elections. And if you do not dispute the outcome of those elections, there is no reason why we have those prayers. My Lord, there is no reason why we have those prayers. That is to say, the applicants have come before this court to dispute the outcome of elections. If they were satisfied with the outcome of elections, there is no reason why they must seek a prayer for arrangement of fresh elections. I just wanted to deal with that. And also, my Lord, we see more cherry picking in his submissions, which is very problematic in this case. Same provision 42, sub rule 8, which he chooses to ignore, reads, for purposes of emphasis, any objection by any member of the SU concerning elections shall be lodged with SJC within 24 hours after announcement of the election results. My Lord, may I refer His Lordship to paragraph, to the founding affidavit of the first applicant. That is page 31 of the records. Paragraph 1.1.
Page 31.
Yes, my Lord. Paragraph 1.1. The first applicant has this to say in his founding affidavit. I am the registered student of the National University of Lesotho, pursuing master degree in Arts in African History. May I end there. Now, my Lord, let us go through Article 42, sub-article 8. Any objection by any member. That is to say, at a point where council is saying, oh no, provision 6 does not work in our favor, but we submit further as a reply to his arguments to say, now clause 8 of Article 42 of the SU Constitution covers even the first applicant. As a member of the student of the National University of Lesotho, as his affidavit in paragraph 1.1 clearly indicates, he's a member of the SU, and paragraph 6 and 7 of the prayers that they seek in the notice of motion clearly indicate that the first applicant wants the annulment of the elections because he's not happy about the outcome of the elections. And as a member of the SU, in terms of clause 8, he ought to have exhausted the local remedies, which he has failed in this particular regard, and which even counsel for applicant admit that they have not been done. Now, my Lord, as regards the issues of SJC that were lodged in that court, I have been advised, my Lord, per my instructions, those are different issues from the issues that the applicants are seeking collectively in this particular court. Those are different issues. In that court, there was no issue of the annulment of elections. There was no issue of dissatisfaction with the outcome of the... There were no issues. These issues are fresh before His Lordship in this urgent court. And the SU Constitution, as an enabling statute, is very clear that if you, as a member of the SU, like the first applicant, per his founding affidavit, if you have the problem with the outcome of the elections, you know what to do in terms of the Constitution. Exhaust internal remedies, constitutional remedies. He failed to do that, my Lord. And he's covered by clause 8 of the SU Constitution.
I thought that's what Tassan is saying. I thought Tassan is saying, well, we are not concerned. The issue here is not the outcome of the elections.
My Lord, as
who won or who lost, but the procedure pre the elections.
My Lord, as I
we denied opportunity to stand. Yes.
Thank you for that question.
I say it's part of the electioneering process.
That is not the true picture of what prayer 6 and 7 reflect. And at the beginning of my reply, I did indicate that Advocate Tassan is just engaging into the Olympics of semantics of English language. Because why, my Lord, would you say, not even you, my Lord, why would the applicant say the elections must be annulled if they are happy about the outcome of the elections? Why would the applicants approach this court to say second and third respondents after 10 days of the order must be directed to arrange for fresh elections. At a point where you say these elections must be declared null and void, what is the ultimate thing that comes to mind as a matter of logic and my lord, as a matter of common sense? Is that you're not happy about the outcome of the elections. So the fact that their prayers are not explicit to say we're not happy about the outcome of the elections, but at a point where you seek annulment of those elections, you're not happy about the outcome. And the fact that at prayer 7, you are saying as an applicant, there must be fresh elections. What is the end result? What comes to mind? Because you want to arrange for fresh elections because you are not happy with the outcome of the status quo. So, my lord, that argument cannot stand in this case. As just an issue of hiding behind English and all of that. What is the ultimate outcome or objective at the end of the day? It reasons to say you are not happy. That is why I said that the elections must be annulled. You are not happy. That is why you're saying elections must be arranged. And in terms of clause 8, read together with paragraph 1.1 of the founding affidavit of the applicant, is a member of the SU. Now, at a point where he was not happy about the outcome or any issue or any objection, he ought to have exhausted local remedies. I also indicated, my lord, that Advocate General is cherry-picking the prayers. He only takes certain prayers, and then in the face of the rest of the prayers that are there, at paragraph 26, at page 26 of the notice of motion, as to the issue of the disqualification of the applicant, there is material non-disclosure in that regard. That because he violated the law regarding elections, of campaigning before everyone else, a decision was taken and he was brought to be given a hearing. Why are you campaigning before everyone else? The law is very clear. And as a person, even contesting for precedence, per his founding affidavit, he was brought, why are you campaigning before everyone? That is still an issue in those courts. Now, as to the issue of who feels threatened, because there is security at the National University of Lesotho, my lord.
And
there is security. So that argument is untenable.
what argument now?
The one Advocate Ts'ehla submitted, my lord, to say even the first applicant cannot go before the SJC because he said the guys at SJC are not, they feel somewhat unfree to sit.
He said the SJC is non-existent.
That is
unless I didn't understand him correctly.
He said other tribunals are not in existence.
He said SJC and other tribunals are non-existent, unless I didn't understand him correctly.
No, my lord. His position submission is SJC is dead.
Oh.
But the problem with SJC, he said in his submissions that some of the respondents are making it difficult for SJC to sit, which is untenable. Because there is different authoritative bodies within the National University of Lesotho. There is security. There is the rector security, my lord, that could provide security to that particular court. So it doesn't make sense, my lord, to come to this court and say, I did not canvass my issues in that court because the guys sitting in that court feel unsafe. That argument is very dangerous, my lord. And that is the issue of disqualification. That is still an issue in those courts. And that court, there is security. They are different. They are very well aware of all of these issues, my lord. Now, at that point where the founding affidavit says, we tried to convene, but there was a play around court, security couldn't help us, management of the university could not help us, then it would make sense why you must come to this court. The founding affidavit is silent on that. It begs the question, why have the issues not fully been canvassed in the SJC? That argument cannot stand and must fall, my lord. And in conclusion, my lord, the constitution of the SU is an enabling statute of the National University of Lesotho to govern the student affairs. And in the face of the internal remedies, constitutionally so, that the applicants, including the first applicant, that they should have exhausted, they have not done that, my lord. They have not done that. We have provided jurisprudence of this court, of the Court of Appeal. We have quoted the constitutional provisions that mark the importance of exhausting these internal avenues that are available, which the applicants have not exhausted. The applicants in the founding affidavit have not also made an allegation as to the impossibilities of exhausting those local remedies. Rather, it is just sentimental arguments to say the guys are making it difficult without explicitly putting it in the founding affidavit, my lord. The position of the law is clear, my lord. Paragraph 43 of the Ramaphosa decision is very clear, my lord. Article 42, 6 and 8 that covers the first applicant is very clear, my lord. The monarchic catering decision of the Court of Appeal is very clear, my lord. Exhaustion of local remedies have not been exhausted by the applicants in this case. We respectfully submit, my lord, that this court declines to hear jurisdiction in terms of the authorities that have provided to his lordship to enable the exhaustion of local remedies by the applicants in this case. My lord, that is the end of the reply.
Yes, like I said earlier, we are both relying on the SEO constitution, and I hope it will be made available.
My lord, may I make an undertaking to make it available?
Those relevant provisions, what they deal with.
My lord, I make that undertaking.
So this was purely on the jurisdictional issue.
Yes, my lord.
I think the court will need some time to consider the submissions. And also after the court will have been furnished with the necessary document, which is being relied upon.
As a purpose.
And that being the case, you will accordingly be informed by my clerk when the ruling is ready. We are not going to take long to make a ruling on the jurisdictional issue in the light of circumstances of this case. That being the case, the court will adjourn. Oh, before that, don't we have another case in the latter? Oh, we have another one. I'm sorry. The court is still in process.